a senior attorney with MNK Law, where we help businesses navigate the challenging legal environment they face today. Before we get into today's video, please do not forget to like, comment, and subscribe to our channel for more resource videos like this one. Today we will discuss employee arbitration agreements and a couple of factors to consider when implementing them. For a variety of reasons, employers often prefer to resolve employment-related disputes through arbitration rather than a typical lawsuit in state or federal court. A key benefit of employee arbitration agreements is the ability to require arbitration of all disputes solely on an individual basis rather than as a class action or collective action. A recent Supreme Court ruling has favorably impacted the enforceability of employee arbitration agreements, but the law is still developing in this area. To start, employers must choose whether to mandate their employees to sign an employment arbitration agreement. In California, Assembly Bill 51 was signed into law October 10, 2019, and it prohibited California employers from requiring employees to sign mandatory arbitration agreements as a condition of employment. It also stops employers from retaliating against employees who refuse to sign such agreements. This bill, however, is currently being challenged on preemption grounds in federal courts. Given that this is currently an unsettled area of law, employers wanting to minimize risk are advised to make arbitration agreements voluntary for employees. And employers are also advised to refrain from retracting job offers to employees who refuse to sign. Employers should strategically implement employee arbitration agreements to obtain maximum voluntary consent. For example, employees may be more likely to voluntarily sign a new arbitration agreement if the employer presents the arbitration agreement as a package with other employee handbook updates for 2023. Mandatory arbitration provisions are also often attacked on grounds of unconscionability, with the argument being that an agreement to arbitrate was unfair and should result in the invalidation of the agreement. Factors such as oppression, unequal bargaining power, and hidden details could constitute procedural unconscionability. The arbitration provision could be substantively unconscionable if it lacks neutrality, limits discovery, limits damages, or is otherwise one-sided in favor of the employer. Arbitration agreements must be carefully drafted to avoid invalidation on the grounds of procedural and substantive unconscionability. At MNK Law, we have significantly updated the provisions of our clients' employee arbitration agreements to comply with the recent legal updates in this area. For more information, visit our website at mnklawyers.com or contact us at info@mnklawyers.com. Thank you and see you on the next one.